Ashley Mascarello, an attorney here at Goodman Law Group, and I'm here with our newest attorney, Dan Frankum. Say hi, Dan.
Hello.
Today we wanted to talk about a topic that comes up frequently when we're talking about open session meetings of the Board of Directors, and more specifically, who can attend those open sessions.
That's right. Arizona law is specific on who can attend duly noticed open meetings of the board. The first thing you need to know is which statute you're operating under, whether you're a planned community or whether you're in a condominium. The Planned Community Act and ARS 33-1804 governs planned communities, and the appropriate statute for condominiums is ARS 33-1248.
That's right, and both of those statutes have very identical language, and the first thing to note about open session meetings and who can attend is that the statute says the meetings are open to all members of the association. So members, I think most everyone knows, just means owners in the association. So that seems pretty simple. You want to check the deed and see who is the actual owner of that unit or lot. So if it's an individual, makes it very easy. You know, Dan is the owner of that lot or unit, or husband and wife owns one unit. That person or those people are entitled to attend a meeting.
It does get a little bit more interesting when the owner of the lot may be in a trust or a corporation or an LLC. You're going to have to do a little bit more research to see who's able to attend the meeting as a member. For an LLC, you'll have to check on the Arizona Corporation Commission to see who the members are of the LLC that would be able to be designated as a member to attend the meeting. Likewise, for a trust, any trustee to the trust may attend the meeting.
That's right. Then we want to look at what that second sentence of the statute says, because it goes on to say, or any person designated by a member in writing as the member's representative. So there's a lot to really unpack with that sentence, I think. In addition to members being able to attend and speak at meetings, if that member designates a person in writing, that representative may attend and speak on the member's behalf.
So in writing is a little vague. Are there any specifics that have to be in writing for a member to authorize a representative?
That would be nice, but no. The legislature doesn't really get into that. For whatever reason, there's no real guidelines in either of these two statutes as to what the form is that the designation should take, what it should look like, what information should be included.
That makes it easy, right?
Yeah, so you make it up. I would think that you would want to have the member's name on there and their signature, and then who the individual is that they're designating as a representative. Yeah. All of those things should obviously be on there, I would think. And then that kind of also begs the question, how soon can an association require that member to designate in writing? Can they bring it and present it at the meeting? I've had some associations share concerns about doing that because they can't look up, well, is this even the owner? Is it who, you know, I need to verify if, like you were saying, if it's an LLC, is this person even entitled to designate someone to represent them?
What advice do you generally give those boards?
I've told them in the past that since the statute doesn't really address it, I think there's a good argument that boards can require that designation in advance of meetings, but I would recommend that they create a policy or resolution and make owners aware of that fact that, hey, for moving forward for open sessions of our meetings, if you're going to designate a representative, we need it the day before, 2 days before, and if you bring it to the meeting, that's not going to be good enough. I think as long as owners have reasonable notice that is the expectation, I think that's a reasonable step for boards to take.
I agree.
The last thing I think that we wanted to note is that the statute says or. As a reminder, it says members may attend open sessions or their designated representative in writing.
So you're saying I can't show up as a member and bring my authorized representative with me as well?
That's exactly right, and I think that there's a strong argument that if that's happening at your open session meetings, that you can object to that because of the or language in the statute. It should really be more appropriately either a member or their representative, not both. So that's something to definitely keep in mind if you have folks that are authorizing people to attend meetings for them. And then keep in mind also that if the authorized representative has been designated in writing, they're entitled to both attend and speak. So you can't just tell them to go sit in a corner and not say anything. So the statute does make that clear as well. But I definitely think that there are steps associations can take to make sure that they're allowing the right people, members, owners, not residents or tenants or anyone like that, and to make sure that they have the written authorization that they're comfortable with.
Great.
And that's what
you need to know.